Good afternoon, everyone. Welcome to Morgan & Morgan's Independent Contractor webinar. Today, we're going to talk about what does that actually mean to be an independent contractor? Why does it matter? What to do if you're misclassified, how it affects you. My name is Ryan Morgan. I'm an employment lawyer here at Morgan & Morgan. I am co-chair of the Employee Rights Group, along with my colleague, Andrew. I have been doing these types of cases here for about 12 years now, and I've handled, I can't even count how many independent contractor misclassification cases.
Hi, I'm Andrew Frisch, and I'm the other co-chair of the Morgan & Morgan Employee Rights Group. Like Ryan, I've handled many, probably dozens of independent contractor misclassification cases. As we'll talk about in a little bit, it's a very common thing to happen to people that are actually employees or classified as independent contractors. We're often asked about what it means to be called an independent contractor. So today we're going to talk about that. At the end, we will have a question and answer period. So feel free to write down your questions in the chat at any time, and we will answer everyone's questions at the end.
Okay, so let's jump in here a little bit and just to kind of throw some questions out there to kind of help frame the issues here is, why does it matter if you're an employee or a contractor? How do you know? What can you look at? What can you think about with your own situation to know if you're being correctly classified? And then, what can you do if you are being misclassified?
It can be a little complicated. So before we get into all that, let's address what it means to be an independent contractor. To keep it simple, independent contractors are workers who typically control their own schedules. They choose who they work with, and they purchase the materials and the tools necessary for their work. Whether you're an independent contractor in the eyes of the law depends on your actual job duties and responsibilities. Most courts use a 6-factor test to determine whether someone is an independent contractor or an employee.
To try to help frame it again, a couple examples that I can think of off the top of my head is I had a case years ago. It was a construction company where all the workers were classified as contractors, even though they came to the company and the job site every single day. They were paid by the hour. The company provided all the materials and tools and trucks and ladders and construction materials, everything you can think of to do the job. And it, quite frankly, it looks like an employee. So that was one that was a successful case. We have numerous cases going on right now where individuals use their car to be a courier and drive around, deliver documents. There's Amazon cases, there's other cases against big companies where they hire scores and scores of individuals to perform these deliveries. And they set the schedule and they set the routes, that they being the company, set the routes, set the schedules. It's full-time employment, working 50, 60 hours a week, yet they're called, contractors. And now, why does this matter? This is important because if you are an independent contractor, you are not protected under the employment laws, technically. You aren't entitled technically to overtime compensation. You aren't protected under the FMLA or the Americans with Disabilities Act, Title VII, or any other employment law claim. Your typical sort of retaliation, harassment, things of that sort. Now, companies can choose to comply with those laws, but if you are a contractor, you are not protected by them.
If your employer misclassified you, it might not be on purpose, but whether or not it was intentional, the misclassification still matters. If you're misclassified as an independent contractor, when you're truly an employee under the law, you are likely not getting paid the proper overtime compensation owed to you. Depending on the circumstances, it's going to be significant, with thousands or even tens of thousands of dollars in compensation at issue.
So it's important, if you think you have been misclassified, if you're listening or go look, if you just Google this, you will see these tests that the courts use. And if you're sitting there and thinking, well, hey, I sure am treated like an employee, I sure do look like an employee, well, then you know what, your instincts are usually right. And if that's the situation, reach out to an attorney, reach out to us. We handle these cases on a contingency fee basis. So we're more than happy to look at what you may deserve, which, as you can see on the screen, back pay, unpaid wages, and other compensation. Like Andrew just said a few minutes ago, it can be significant, tens of thousands of dollars, potentially other penalties that could be in place depending upon where you worked, what jurisdiction and laws that we could sue under. I look at it maybe in a little bit too much of a simplistic view, but you're doing the work. You need to be paid what you are owed and what you should be owed, regardless if they've misclassified you.
Sometimes people who think they might be misclassified as a contractor, they don't contact a lawyer for their employment claim because they're worried about the attorney's fees that they might have to pay, or they're worried about retaliation, frankly, possibly the loss of their employment or something else. But the law protects you against retaliation. And at Morgan & Morgan, we don't charge any fees unless we win your case. So we evaluate your case for free. All you have to do is call us or contact us. You can use the information that's going to be in the slides. The consultation's free. But we don't charge anything while we're litigating the case. We forward the costs on behalf of all of our clients, so it doesn't cost you anything in court costs or anything like that. And fees, we don't get paid a retainer up front, or as the case is going on. We only get paid a fee if we're successful at the end of your case, whether it be by settlement or by judgment.
And I would definitely piggyback on with Andrew before we get into the Q&A about, each case is unique. In the independent contractor realm, the facts do very much matter. Every case is a little bit different. So I would say take advantage of the resources you have here with us and asking us. It costs nothing to do so. And then if you decide you just don't want to pursue it, that's also your choice. We're not going to do anything. We're not going to file a claim or contact the employer until you give us the A-OK to move forward. But at least get the information, at least get an initial analysis from an attorney so that you know your rights. And now we are going to go into the question and answer session here. So if anybody has a question, please feel free to type it into the chat button and we can answer it. Or if you want to ask it verbally, just make sure you unmute your mic and we will answer any and all questions that we can. I did have one question that was sent to us prior to this webinar beginning. It had to do with tax forms and being paid as a 1099 or being required to sign an agreement. That's not going to win or lose your case by itself. In fact, the law says you are not supposed to actually look at the label that you put on the relationship. You look at the actual facts. It goes back to what we discussed. Who has the control? Who is telling who what to do? Who is setting the parameters of work? Is it full-time work? Who's providing these all the materials? It also looks at how integral the job is to the business. So even if you are classified 1099, or maybe they made you sign an independent contractor agreement, or I've seen cases where they've made workers, set up their own corporate entity to get paid through. That doesn't mean you haven't been misclassified. You still can be misclassified under those circumstances. Now I see Scott. Go ahead, Andrew.
No, I see Scott has asked a question, and I'll read that out so everyone can see it or can hear it. If someone received a Christmas bonus that was considered a 1099 independent contractor, would that lean towards them being an employee or an independent contractor? That's a good question. I think we would need some more facts to truly analyze that. The test to oversimplify things really is if people look like an employee and they smell like an employee, they're probably an employee. To me, that sounds like typically you wouldn't pay a Christmas bonus to someone who's truly a contractor although, so it wouldn't be dispositive of the issue, but it does lean towards being an employment, a true employee rather than an independent contractor. Economic reliance is one of the things that the courts look at to determine if someone's an employee. So, for example, if you only work for a single employer, usually because you're working so many hours, you can't possibly work for another employer. That's something that is going to gravitate in favor of someone being an employee. That's also typically a scenario where you would see that someone would get a Christmas bonus because it does look and smell like employment. So while that one thing by itself in a vacuum wouldn't necessarily dictate that you'd be found to be an employee, it is certainly evidence that I think a court would consider you to be an employee, and the law would as well.
Good question, Scott.
Ryan?
Yes.
So if you're making your own schedule, is that does that disqualify you? Would that be considered more of a independent contractor versus an employee?
It doesn't automatically disqualify you because the way all these factors we've been talking about, the way the courts weigh them is one factor doesn't decide it. It's sort of a combination, right? If maybe one's against you as a contractor, but all the other five are for you as an employee, I feel pretty good about things. So I guess my follow-up question, though, on your schedule question is, when you say you can make your schedule, are you given parameters to make that schedule, right? Is there certain requirements you have to meet with the schedule or certain demands you have to meet, or is it truly you can do it at any which time at all during the day or the week?
My case specifically, there's usually deadlines that are associated with that.
Okay.
Like I need these projects and I need them done by XYZ, but that's not always the case.
Okay. I would say if it was hey, we need this project done, and I'm making up a scenario here,
Sure.
a month from now, right? And you've got a month to do it and you can do it on your own time or whenever it was, that would lean towards more of a contractor. If it's, hey, I want you to be, you have these projects, they're due within a month, but I need you in the office a few times a week, or I need you available, a few times a week for a few hours a day on that. Well, that starts looking a little bit more like an employee. We'd have to start looking at those other factors we discussed to weigh it. Because again, going back to kind of the big picture is you have to weigh all these factors together. And look, it is rare. It is rare in a case that we have all six factors 100% on our side of being an employee every single time. There usually is a little bit of gray on some of these issues. So, it wouldn't just automatically disqualify you.
And one last question. I know in California, you mentioned the ride share. There's a big push in California towards the big dog in the picture there. Is that, do you have criteria or do you have knowledge of that scenario? Because obviously anybody that's truly driving for them I'm in Florida, so high season, you're 24/7. You're pushing your 12 hours a day.
That's that's the proverbial $1 million question there, right? But yes, so California has its own state law sort of analysis for employee versus an independent contractor. They call it an ABC test. New Jersey also has one, I think Massachusetts as well. A few of these other states where it's even easier than what we've described to be considered an employee. And then in California, you also had some of this legislation that the legislature there passed, basically requiring that Uber and Lyft drivers and other, rideshare drivers be considered employees. It's definitely a big debate here. Now in Florida, we don't have a state test. We fall into the federal test, which is what we were sort of just describing a little while ago. Now you've had some decisions like the Florida Unemployment Compensation Appeals Commission ruled that Uber drivers and other ride shares are contractors and not employees. That's under their test. They use their own test. That's a little bit different than what we've talked about here. But I would say in Florida, I think the Uber misclassification type cases are tough. They're tough.
Okay, good to know. Thank you.
Welcome. All right. Well, thank you guys.
Okay, sorry. Thanks so much for watching. And if no one has any other questions, please share this with anyone you think might be affected so they can be sure to fight for what they deserve. If you think your employee rights are being violated, you can also give us a call or reach us on the web. You can reach us by telephone at 888-506-5405. Thanks, everyone.
Have a good day.